This conference will now be recorded.
Welcome. My name is Charity Rouse. I am the Director of Local History for the Spartanburg County Public Library System. Tonight, we will be talking about deeds and land records, particularly those here in South Carolina. So, what is a deed? I mean, it's in the title, but what does that mean? A deed is the official registration of land ownership, recording a grant, purchase, sale, or other transfer of land. And land is historically how our ancestors here in the United States, at least, really saw their value, particularly when we were an agrarian society living off of the land, lots of farmers. So owning land was a sign of status, but it was also a sign of, hey, I can take care of my family. One of the things that makes land records somewhat unique in various of the types of civil records we use in genealogy is that the owner of the land has a copy, both the seller of the land and the purchaser of a land get a copy of the record, and then there is a third copy that is registered with the court. And once that happens, if the court has record loss, fire, storm, tornado, other, war comes across, whatever the case may be, if there's record loss, often one or the other of the buyer or seller of that land may very well take their deed back in and have it re-registered. So these records do tend to survive, whereas some of the other records may not. There are types of land records that you might find. Acquisition is in the left column. Disposition is in the right-hand column. So acquisition is the purchase, disposition is the sale. And most of this list is the same for each, so I'm only going to cover it once in each, but there are two that are different. And I'll start with the top left, the patent or grant. So a land patent is a governmental gift or sale of the land, and it's granted. The deed is if someone is purchasing from another person. Quit claim is an instrument or document where the guarantor or the seller releases the right or interest in the property, possibly when it was inherited jointly through a will or intestate process, and we'll talk more about that in a minute. It can often be triggered by the death of a widow, where they haven't been able to settle land because of dower, which we'll also talk about in a little bit. Inheritance by will, when someone dies, they can leave their property. Inheritance by intestacy. If you die without a will, you die intestate. And if you die intestate, there are court processes that have to be gone through as part of probate to deal with any property or belongings that the person who died might have. So that creates records. And each state has different ways of dealing with this and different laws that are followed to divide up the property. There may be a silent inheritance or silent transfer of land. And this is typically where land just goes down generation by generation by generation through a family to typically the oldest son. And then it's never registered with the court. The family just agrees, hey, this is who takes it on. And so sometimes you don't have records of those transfers. If there is a court suit for a variety of reasons, the court might be called in to settle a land dispute or award land to someone collecting on a debt, that kind of thing. In one case, I have seen particular guy is the agent of the court. So anytime someone has to sell land in order to pay their court costs or to pay the debt from a court case, that person is the one who handles the process of the sale on behalf of the court. Sometimes it's the sheriff of the county, other times it's an appointed position. A partition or a division. When land is inherited jointly, there had to be some way of equitably dividing the land. You don't want to just say everybody gets 10 acres if part of the acres aren't usable and part of the acres have a gold mine. You know, those types of things, you have to have it evaluated and figure out the relative worth and how to divide it equitably. Assignment is where an heir can assign their interest to someone else. It's a transfer similar to what we would do with a car title. It could be bounty land, which we'll talk more about next month. The person who earned it might not want to move west, so they assign the right to someone else, typically for a payment of some sort. You also see siblings assigning their interest to the kid who stayed home and cared for the parents, or things like that. So you will see on occasion an assignment. And then, of course, the final is the escheatment, and that is when on the disposition, the granting agency, the government, the agent of the government, that they have reneged on their responsibilities. You see this more in the federal land states at the very beginning, which we'll talk about more next month, but little preview, where if someone gets the land and they agree to within 5 years, they will have cleared X amount of acres and they will have built a house and they will have lived on the land for at least 2 years. And at the end of that 5 years, they have not done all of those things, then that land is taken back and then resold. So those are the types of records you may very well find. This is an example of a land grant from Virginia, 1704, and you will notice a few things about this. One of the things is that it is Marguerite, Lady Culpeper, who is the agent of Thomas Lord Fairfax and Catherine, his wife. It's on the northern neck of Virginia, which is now Richmond County, which is nowhere near Richmond, the capital city of Virginia. And so these are on behalf of Lord Fairfax and his wife, Catherine, who have been given proprietorship of this part of Virginia from the crown in 1700s. I don't remember which king or queen that is, but Marguerite, Lady Culpeper, is acting as their agent. And so this, however many times great-grandfather Abraham Goad in 1704 is getting land. I love the handwriting on this one. Not all of them have great handwriting, but you're going to have lots of handwritten deeds to look through. So what does a land record tell us? Well, a land record tells us location, location, location. It helps us place our ancestor or the person we were researching in a particular location at a particular time. It helps us know dates and time periods of possible moves. Often, a landowner would sell their land in one place, move to the new place, and purchase land. Sometimes you do see them go to the new place, purchase the land, come back, and then sell the land in the original location before they move the rest of the family west. It depends. You find possible dates of death, particularly of women, Again, we'll talk specifically about women a little bit later in the program. You do find the names of friends, associates, and neighbors. Friends, family, extended family. Elizabeth Shown Mills is a national genealogist. She calls it the person's fan club. You may see certain names that keep reappearing and reappearing and reappearing in records for your family. And that's usually a good indication that they are either close friends, they may be cousins, or in-laws, those types of things in the same church. So you find people who are witnesses, who are adjoining property owners, that sometimes you can find those neighboring people and put pieces together that, oh, that's how they met, for a husband and wife, that kind of thing. You will discover the relative wealth or poverty of your person that you are researching. Remember, in that agrarian society that we started out with here in the New World, land was wealth, and a lot of people didn't have much ready money, but they did have land. Sometimes, particularly in the early land records, you will find a chain of title quoted that this is the land that I bought in this year from so-and-so, who bought it from so-and-so, who got the land grant from the crown. So sometimes you get those types of chains of land ownership, which can be very helpful. Sometimes you get an occupation. Here in Spartanburg, there was a gentleman by the name of William Walker, who was a hymn book editor and known now as Singing Billy Walker. After he published his first major hymnal, which was the Southern Harmony, he always signed his name William Walker, ASH, author Southern Harmony. And that differentiated him from the other 4 William Walkers who were active in Spartanburg County at the same time. So knowing which William Walker is really helpful. What's not helpful is he bought the land that his widow had prior to being that William Walker. And so that makes it a little more difficult. Age, men were usually about 25 or older before they first purchased land. It's a rule of thumb. Not everybody is that old. And sometimes it's inherited, so that throws things off. Witnesses did have to be at least 14 throughout everything that I know about land deeds in South Carolina particularly. And that tends to be the case. Often it was 18 or 21, but you had to be at least 14 as a witness. So a couple of key definitions. Abstract is a skeletal summary of the important information in a document. We have books of abstracts in the Kennedy room, and someone has gone through and they have decided that these are the more important pieces of information, and I'm not going to tell you all of the meets and bounds, but I'll tell you who the neighboring landowners were, those types of things. A transcript is a verbatim word for word copy of a document, misspellings and all. A grantor is the seller of the property, and a grantee the purchaser of the property. Fee simple means that it is owned outright. There are no restrictions on that land. A fee tail means that there are restrictions on the property placed by a prior owner or agreement. Sometimes that also means there's a mortgage on the property. So state land states are the 13 original colonies, plus Maine, Vermont, West Virginia, Kentucky, Tennessee, and Texas, and Hawaii. So except for Hawaii, those other states are contiguous to those original, well, except for Texas as well, contiguous to the original colonies. Public land states, the other 30 states. And again, we will talk about public land states in December's program. So a couple things to consider as you are looking at and looking for land records. The time frame and location. These are most often in the United States held at the state or local level. In South Carolina, these are held at the county level now, but as you go back in time, the state land grants are going to be held on the state level because there weren't that many counties. So the location of these records is going to change through time. So at the Topeka room, good grief, I jumped states. At the Kennedy room, we have the up to about 1900, but we do have the earlier state land grants as well. Practices and laws can and do differ from state to state. You may find your ancestor not just as the grantor or grantee, but you may find them as a witness, court official, surveyor, chain carrier to help measure everything, etc. So clerk of court. So you're going to want to look at a lot of different records, because if you can prove that they're the next door neighbor of this person and that person and that person, that helps you place them even if you can't find them owning a particular piece of land because of record loss. You will want to consider dower rights for women and the age of children, particularly if the father of the family passes away and there are minor children, usually meaning under 21. That will tie things up for a while, can tie things up for a while. And there are records of mortgages or liens on the property. So some of those survive, not all of them do, but those can be another way to tell what's happening and the financial situation of your ancestor. So this is an example of a deed in 1843, a little more recent than the 1704. And this is in Marion District down in the PD of South Carolina. And Robert Rogers is selling Joseph Allen, my great-great-grandfather, some land in Marion County. You will note in the top here, it says Robert Rogers to Joseph Allen. It says South Carolina, Marion District. Shown to all men by these presents, I, Robert Rogers, of the state of Louisiana, and the parish that he's in, have granted, bargained, sold, and released, and agreed to sell and release unto Joel Allen of Marlborough District. Now, there's a question here as to whether it's Joel or Joseph. They are brothers. So, and it has a plantation. Now, something to remember here, Robert Rogers is in Louisiana. It is highly likely that he also recorded this sale in Louisiana where he was living. So again, it may be that it's recorded in multiple places. So where do you find land records? Well, you find them in the courthouse or the county offices in South Carolina, in the Register of Deeds office. Some do have online access and many do not. Ours does not. In the library, local library, public library, on microfilm, as well as having printed abstracts or transcriptions, which may be available for certain locations. Family Search is a wonderful resource. They have taken this microfilm that has been made of all of these court records, and they have scanned that microfilm. So for Spartanburg County, all of our deeds and land records up through about 1900 have been scanned and are available on Family Search from home. You don't even have to come into the library at this point to be able to search. Note, they are not indexed. other than on the film indexes, which I will show you some examples of in a minute. So you do have to search by location and look at the records online just like you would on the microfilm in our room. You may find land records at the state or regional archive or library. In Kansas, it would be the Kansas State Historical Society. In Virginia, it would be the Library of Virginia. Depending on the state, it depends on which organization holds those records. It is a multi-step process no matter where you find the records. So we're going to go through that process a little bit. In Spartanburg, as I said, the library has microfilm of the records up to about 1900. The Spartanburg Register of Deeds office has all of the deed books starting with 1A and coming through current. And I haven't checked recently as to how much they're allowing people into the room there, but do call or check their website before you go to a place right now, particularly with COVID. They don't do a lot of help for you. It's kind of, they're the books. So kind of knowing what you're looking for or taking someone who's done some more of the research with you, that can be helpful. The copies of the pre-1900 deeds, as I said, are both at South Carolina State Department of Archives and History. In Columbia, Kennedy Room has copies, and they're all on Family Search now too. These records are kept forever. This is one record set that you may have to title search all the way back to the beginning, and so they keep the records. They are also known as mean conveyances, which is a private owner to private owner, but you may see that term as well. So, this is a picture taken in the Spartanburg County Register of Deeds office. It's been a couple years now, but I don't think they've done major renovations. And the books that you see here are the indexes. And on the back wall, you have in rough order from book 1A to book 15D or whatever it is now. And basically what happens is they have 1A, 1B, 1C, 1D, 1D, et cetera, et cetera, et cetera. And then they go back to 2A, 2B, 2C, 2D. And then early books, you may see it as AA. By the time they get to 3 and 4, they just say 4A, 15A, that kind of thing. So these are cross indexes. These have both the grantor and the grantee, as opposed to just the grantor index or the grantee index. But they're lovely large books. And then these are some of the 12 and 13 letter volumes. And so they're big, but they're fun to look at. So this happens to be from our microfilm, but this is a page from those books, and it tells you how the index works. If you are working with the index for the first time, I would find the description of how that particular set of indexes is supposed to work. There were a number of different companies around the country who did indexes for courts. And so each one works similarly, but you may find slight differences. So for family indexes, you also find some clerks of court follow the instructions and some don't as closely. It happens. This is the sub-index listing in one of the physical books, and you see surnames arranged by phonetic groupings. And so you might have B-E-L, B-A-L, maybe in the same grouping. And then it tells you what page of the sub-index to look for. And then this is one where it told us to go to 88, so we've gone to 88B, and these are for Dunlaps in Spartanburg County. And you will see a couple things on this direct index. You will see the grantor's name, last name, and then they divide it up into 3 different columns for ease of page scanning for finding who you're looking for. If you see et al., that is usually an estate situation. So you may be looking for a child's name and it may be listed under a sister or under their mother. So do check the et als for the date that you're needing, knowing that some of these don't get registered for a while. The grantee is the person who purchased. So this was Richard Chesney, purchased from Alexander. S.R. Grisham, purchased from S.G. Dunlap. It tells you what book it is. So N00, 4V, 5P. It tells you what page in that book. So 281. The year of instrument, which is 1806. The year of record, which is 1813 on this first one. So you see there's a discrepancy. Sold the land and then didn't actually register it for a while, for whatever reason. How many acres it is. So you may find 200 acres, you may find 1 lot on Evans Street. So town. And then this last one is, and you get the location here, a release and acknowledgement. That can be one of the transfers that we were talking about, that sometimes it's just, we need to do the paperwork to say, yep, we're all signed off on this. So this is the Dunlap to Mr. S.R. Grisham. And again, it says it's a deed, state of South Carolina. Know all men that these presents that Samuel Dunlap of the state for said, county of Spartanburg is in consideration of. And so this just goes through the considerations of what's being sold. So it tells you who's selling, who's purchasing, how much they're paying, that it's being released to the purchaser, their heirs and assigns forever. Once you've read a bunch of deeds, you start figuring out the legal formula of the document. And then sometimes you get things that get interesting. But this does tell about the roads that it was leading from Barry's Mill to Spartanburg Courthouse and the dimensions of that. This is what in the physical book, it's not the world's best picture, but I'm the photographer, so it's a snapshot. But you can just see the various things, and you can see you don't get a full page. They finish up the last one. If you're lucky, they stick a line in it before the next one. And you get witnesses down here on the left. So again, there's a format that is usually followed by most clerks. This is another example. This is another reminder that sometimes things may be filed in multiple places. This William Irwin, sorry. The deed was actually filed in Greenville County, and the copy was sent to Spartanburg, and Spartanburg County Clerk then put it in the Spartanburg book as well, simply because the land was in Spartanburg County and the landowner was in Greenville. I'm not sure if it was in the Greer area or not, but especially when you're talking about land that's on different parts of the near a county line, it could go either way. Some things to remember about women. In South Carolina, women were seen as a gender to be protected, not that they would be landowners particularly. And so there was a dower right. And that dower right stayed active as a law for far longer than it did in many states. It actually stopped around 1985. And the dower right typically meant 1/3 life interest in any property, real or personal, but not the right to then bequeath that property. So she had an interest in it, a life interest in it, but not ownership of it. If she remarried, she lost the dower rights unless the will specified otherwise. And I have seen a couple, and that ended up back in court a couple of times. For a long time, women could not own property unless they were a widow or single, never married, without brothers in some cases. And so you are trying to just make sure that the woman is taken care of. Now, women could be, and that concept is called femme covert, which I forgot to put in here. Sorry about that. Femme sole is a woman acting on her own behalf. You do see that for a lot of widows. You do see that also for some married women, but they had to go through a process to be declared femme sole so that they could own property in their own right or run a business in their own right. So the dower, the third interest of the widow for the real property of her deceased husband, release of dower in South Carolina up through 1985. If a man sold property, his wife had to be taken to court, and she had to testify in a room away from the husband to a court official saying that she was okay with him selling this property. It was, again, a protection for not having the woman end up impoverished and on public assistance, but that she was fully in agreement with this act of her husband. Oh, there's where femme covert and femme sole are. And so in femme covert, the husband is acting on behalf of both of them. And this is from English common law. So dower releases are most often seen at the end of the deed, or sometimes a couple pages later. So in South Carolina, if the man was married and he was selling land, you have to look for the dower relinquishment, or it wasn't a legal sale. So in 1884, Harriet Bethea is doing a dower relinquishment, states that she's the wife of John R. Bethea and that she is okay with this sale of property. And so, and it's the sale is up here. It's actually to one of their sons. And so this is the witness statement there. And then they asked her, "Are you okay with this?" And she said, "Sure." And being legalese, it takes a little bit longer for them to say that. Now this is a slightly different one. This one's one of the ones that you sit there and you start scratching your head. Amanda Thornhill was third great grandmother on one of my lines, and in 1855, John S. Kelly was giving to A.M. Thornhill, state of South Carolina, Darlington District, consideration for $150 that she paid him, and also in consideration of mutual love and affection, which says typically that means that the price paid is lower than the actual value of the property. And it says, unto his sister Amanda Thornhill, could be sister-in-law. Kelly could have been her first married name. I'm still working on that. Every document I find brings up more questions for her. He's going to allow her to stand seized and possessed to use the property. Her heirs and assign of certain tract of land now occupied by her, bounded of this. It was conveyed from James Hunter to Sarah Kelly, and it's his interest in that tract. and he is holding it for the sole and separate use of Amanda Thornhill, free from the control or liability for the debts of her husband. And he does further covenant and agree that whenever hereafter Wiley Thornhill, the husband of the said Amanda Thornhill, shall depart this life, that he will then, on the requisition of the said Amanda or her children, if she be dead, release to her or them the lands as described, and perfect the title, securing to her or them a fee simple title therein. So this is a fee tail. There are conditions. Her husband, Wiley Thornhill, has to be dead and his debts are settled. That's 1855, and there is a later deed that is from a Mary Thornhill to Amanda Thornhill, or sorry, Mary Kelly to Amanda Thornhill, deeding that same property from the description over in the early 1870s. Part of it is, I think John had passed away. Figuring out which John Kelly is which John Kelly in that area is a little bit difficult. And also by that point, Wiley may have passed away or been declared dead. Who knows? So there are a few key measurements that you're going to run across when you are working in these deed records. I know people who spend time and actually plat out the property that their ancestors owned. I haven't attempted that at this point, simply because I don't trust my math and my measuring. But that's just me. A plat is a drawing and the accompanying text, usually prepared by a surveyor. You don't get these for all properties, but you do get them for many properties. We have 4 rolls of microfilm of just plats for Spartanburg County. But sometimes you get a little sketch in the deed book itself if something is particularly complex or lots of inheritors or that kind of thing. So a pole or perch or rod is 16.5 feet, and 4 rods equal 1 chain. A chain or gunter chain is 66 feet long, and it is made up of 100 links of 7.92 inches each. This is why you need good math skills. A section, and this is what you normally see in federal land states. 1 square mile, 640 acres, with 36 sections in a given township range in the final form of the rectangular survey system. In the original 13 colonies, plus those other state land states that I mentioned earlier, those sections just don't appear because that A, takes a little bit more level terrain than most of the eastern seaboard has, and B, was an imposed system as land was opened up. But we'll talk more about sections next month. So a plat map, and this is an example from here in Spartanburg County for 1859 for William Willis. And I'm going to show you a little closer because this, I have to say, we picked this one for the presentation because it's pretty. It is a beautifully drawn, wonderfully illustrated thing. So William Willis's land, you get Israel Willis's land, you get the creek, you get the river, you get 10 chains per inch as the scale. You get the name of the ford here. You get how many acres are in parts of it. You get where the structures are. See that pretty little house there in the middle. At the bottom of the page, you need another house over here. You get that the above plot represents a tract of land surveyed William Willis conveyed to him by deed of gift from mother, and hath such shape, boundaries, and abuttings as the river and the red lines. So he's inherited this, and he is plotting out, hey, here is where my property is. This is my part of this. Eventually, you do get more blueprinty looking and more looks like they're drawn with a ruler, I guess would be the best way to say. This is a 1906, and this is down by Ezel Street in the city of Spartanburg, by where the Spartan Inn was. And if I'm remembering correctly, this would be about a block off of Main Street, and where I may have been walking up the back of the block where Spartan Inn was, down toward where the block before Cribs, I believe, if you're headed south from Morgan Square or west from Morgan Square. So you get to see where the plots are. So towns have more regularly laid out plots than the county part. So that's just a little bit about our deeds and land records, and I will take some questions. I'm going to hit stop recording.